Welcome to Frank Bruno Law. I am Frank Bruno, an elder law, probate, estate planning attorney. So I just wrote a blog post on the Britney Spears situation. Right? Britney is in another part of the country. Right? Here in New York, we do not have conservatorship. We have the same area of law. We call it guardianship. In her neck of the woods, it's a conservatorship, and she has been under a conservatorship for 13 years. So some information has trickled out, some news media accounts, and publicly she's saying, I don't need a guardianship anymore. Right? She said, I don't need a conservatorship anymore, but that's really the same thing. That's when there's a functional limitation. Someone is applied to the court, and the court has named a conservator/guardian for the person. And that guardian takes care of the person's physical well-being and financial well-being. And that's the big issue for, at least publicly, what we can think of, the money issue. She can't control her own money. And based on the rumor mill, she can't control her own body. She doesn't have autonomy to deal with issues of birth control, and having another child. And it's quite significant. So, say what you will. We don't want guardianships in our life. If we need to do it to look out for the best interests of a loved one, of a family member, of a close friend, well, then it's something that we can handle. But you don't want a guardianship for yourself. So we can use a power of attorney. We can use a trust. We can set up in advance the systems and the controls that we want should someone out there say that we're incapacitated. Or if in fact we are incapacitated, right, based on a condition, a stroke, a dementia, a physical ailment, a car accident, an illness, an injury, something. Well, we can set up an incapacity plan. So, from Britney Spears all the way around, this article was submitted to my chief webhead, and it will be posted, and it's going to go out as part of my newsletter next week. Okay? Stay safe, be well.